Okay, let's jump straight in. We make agreements all the time, don't we? Setting terms, conditions for buying a phone, renting a place.
Absolutely. Contracts are everywhere.
But what about something as fundamental, as personal as marriage? Can you actually put your own specific conditions, stipulations into an Islamic marriage contract? The nikah.
It's a fascinating question.
And if you can, what kind? What are the rules? And maybe more importantly, what happens if someone doesn't stick to those conditions?
These aren't just theoretical legal points, you know. They get right to the heart of how the marital relationship is understood in Islamic law.
Which reveals a lot about how different interpretations balance, well, divine law, human agreement, and just the practicalities of life, right?
Precisely, the whole interplay.
And that's exactly what we're diving into today. The complex, sometimes quite surprising world of stipulations in Islamic marriage contracts.
A really rich area.
Definitely. And we should say, this deep dive is made possible because the University of London makes these kinds of educational materials available. We're really grateful to them for providing access for educational purposes.
It's a fantastic resource.
This exploration is brought to you by Sinorbit Academy, Sri Lanka. And look, if any of you are gearing up for exams on this topic, maybe you're students at Sinorbit Academy, then seriously, good luck.
Yes. Best of luck with your studies. Hopefully this helps.
Our goal today is to really unpack the source material you might have, pull out the key knowledge about what makes a stipulation valid or void, or even something that cancels the whole marriage.
And explore those differences between the legal schools and sex. That's crucial.
Absolutely.
Okay.
And we'll definitely be getting into that specific concept of temporary marriage murator.
Right. So the aim isn't just to list rules, it's to help you understand the why behind them. Why do schools disagree? What principles are they focusing on?
So by the end, you should have a much clearer picture, a solid handle on the main issues and differences. Ready for discussion? Or, yeah, ready for that exam.
That's the plan.
I find this stuff really compelling because it just shows, even in something like religious family law, which you might think is totally set in stone, there's actually incredible depth, different takes, different interpretations. The source material we have is like a map, showing these different legal paths drawn out over centuries.
It really highlights the dynamic nature of legal thinking, doesn't it? How jurists grappled with applying core principles to real human situations, real agreements.
It's a living tradition, engaging with life while trying to stick to its values.
Exactly.
Okay, so let's start with the basics. Stipulations in the marriage contract. What exactly are we talking about here?
Well, fundamentally, a stipulation in nikah, the Islamic marriage contract, it's an extra condition, a term that the couple agrees to put into the contract on top of the basic requirements set by Islamic law.
Like adding specific clauses to a standard form.
Precisely. And the source material confirms right off the bat that adding stipulations is generally allowed in Islamic law. It's not a foreign idea.
So the principle is there. Parties can add conditions.
Correct. The complexity and where the disagreements really kick in is around what kinds of conditions are allowed and what happens legally if they're included. Because, like you said, not all stipulations get the same treatment.
Right. And the source gives us a really helpful way to break this down. 3 main categories. This framework is key.
It really is. It helps navigate the different outcomes. So first up, you have stipulations that are seen as valid and enforceable. These are legally binding. Both parties have to stick to them.
Okay, valid and enforceable. Got it.
Second, there are stipulations that are considered void. They have no legal power themselves, but, and this is a really important but, the marriage contract itself stays valid. The void condition is just sort of ignored, legally speaking.
So the bad clause gets tossed out, but the marriage survives.
Exactly. And then the third category, the most serious one, these are stipulations considered so fundamentally against the whole idea of marriage that they invalidate the entire marriage contract. The marriage is basically null and void right from the start because of that condition.
Wow. Okay. So, valid and enforceable, void, but marriage okay. And also invalidating the whole thing. And we're going to look at each of these, seeing where the main Sunni schools, Hanafi, Maliki, Shafi'i, Hanbali, and the main Shia sects, like Ithna Ashari and Ismaili, line up. Or don't.
Exactly. The disagreements really show you the different legal thinking, the core principles each school emphasizes.
Let's start with the easy one, hopefully. Category 1, universally valid stipulations.
Yes, this part is pretty straightforward. There's broad agreement here across almost all the schools and sects. Any stipulation that just reinforces the normal expected effects or outcomes of marriage is considered valid and enforceable.
Reinforces the normal effects. What counts as a normal incident of marriage, and how would a stipulation reinforce it?
Good question. Normal incidents are basically the standard rights and duties that automatically come with a valid marriage under Islamic law. The source gives two really clear examples of stipulations that just reinforce these.
Okay.
One is agreeing on the specific amount of the dower, the mahr, that the wife is entitled to receive. The other is agreeing on the specific amount of maintenance, or nafaka, the husband has to provide for his wife.
Ah, okay. So dower is required anyway, and maintenance is a standard obligation. These stipulations aren't adding something totally new, they're just nailing down the specifics, the amount, of something that's already part of the deal.
Precisely. The obligation to pay dower exists. The obligation to provide maintenance exists. By stipulating the amount, they're just defining an existing legal requirement more clearly. They work with the inherent rights and duties, they don't try to change them.
So because they just specify rather than contradict, everyone agrees they're valid and must be followed. Makes sense.
Exactly, no controversy there.
Okay, category 1 sorted. But now we get into the trickier stuff. Stipulations that try to vary a normal incident of marriage. This is where the paths diverge.
This is really the core area of debate, and the differences come down to really fundamental ideas about what the marriage contract is and how much power the couple has to shape its legal effects.
Let's take the majority view first. Who holds it, and what's their logic?
Okay, the majority view is held by three of the big Sunni schools, Hanafi, Maliki, and Shafi, and also by most Shia sects, although we'll see a key Shia exception later regarding time. Their central idea here is that the effects of the marriage contract are immutable.
Immutable, meaning they can't be changed by what the couple agrees.
That's the idea. From this perspective, once you have a valid marriage contract, the rights and duties that flow from it are set by the law itself, by Sharia. They believe these aren't things the parties can just decide to alter or waive in their contract. The law defines the consequences, not the individuals.
Okay, so if a couple tries to put in a stipulation that varies one of these immutable effects, like, say, the wife stipulates she doesn't have to live in the marital home, or the husband agrees he won't take a second wife, things that go against the standard legal norms, what happens then, according to this majority view?
Any such stipulation is seen as completely void. No legal force, no binding power. It's treated as if it was never written into the contract.
Void.
Oh.
Okay, but does that void stipulation wreck the whole marriage?
No.
Yeah.
And this is absolutely crucial. This is where the doctrine of severance comes in. For this majority view, the invalid stipulation is simply severed from the contract. Cut out, legally speaking.
Severed, like snipping a faulty wire out of a circuit.
Exactly like that. And the marriage contract itself remains perfectly valid. The marriage goes ahead based on the standard, immutable legal effects, as if that void stipulation never existed.
Let's make that concrete. Say a wife puts in the contract, my husband agrees not to take a second wife. Polygyny is generally allowed for the husband in Sunni law, right? So, under this majority view, Hanafi, Maliki, Shafi, what's the result?
That stipulation, no second wife, is seen as trying to change an immutable incident. So it's declared void, it gets severed from the contract. The marriage itself, still valid.
And the practical consequence?
The husband is not legally bound by that promise. The wife cannot legally stop him from taking another wife based on that clause, nor can she use his doing so as grounds for divorce because he broke that specific term. Why? Because that term never had any legal standing to begin with. The standard rules on polygyny just apply.
Wow, so they might have thought they agreed on something really important, but legally, under this view, it just evaporates. The marriage stands, but that specific promise is gone.
That's the effect of combining severance with immutability. The legal framework of marriage is seen as overriding individual agreements that conflict with its established norms.
Okay, that's the majority position. Now, the Hanbalis, the source, flags this as a key difference. How do they see it?
The Hanbali school approaches this very differently. They put a much greater emphasis on marriage as a contract and on the need to honor the agreements people make.
And the source points to a specific basis for this, a verse from the Quran.
Yes, absolutely. The Hanbalis lean heavily on Surah 5, verse 1, the command, "O you who believe, abide by your contracts."
Oh, you who believe, abide by your contracts. That sounds foundational.
It is. And for the Hanbalis, this verse strongly supports principles like freedom of contract, the idea that people have broad freedom to set the terms of their agreements, and also pacta sunt servanda.
Pacta sunt servanda agreements must be kept.
Exactly. They apply these core contract principles directly to marriage.
So based on abide by your contracts, what's the Hanbali rule for stipulations that vary the normal incidents? Sounds like they'd be much more open to them.
Much more. The Hanbali rule is starkly different. Any stipulation is valid and enforceable unless it's actually forbidden by Islamic law itself, like agreeing to do something haram, or it goes against the fundamental essence of the marriage contract.
Contrary to the essence. We'll circle back to that, but basically they're saying almost any condition changing the standard setup is okay, provided it's not illegal or doesn't destroy what marriage is.
That's the broad freedom they allow. They prioritize what the couple explicitly agreed to, seeing it as binding because of that Quranic instruction. And the source uses those same examples we discussed.
Like the husband agreeing not to take a second wife,
Valid under Hanbali law.
or the wife being free to leave the matrimonial home whenever she wants.
Also considered valid under Hanbali law, they don't see these as violating the essence of marriage, and they aren't forbidden acts, so the principle is, you agree to it, you stick to it.
Okay, this is a huge difference. Majority view, void. Hanbali view, valid. So under Hanbali law, if a husband agrees not to take a second wife, a valid condition, and then he breaks that promise, what happens?
Right, this is where the Hanbali view has real teeth, unlike the majority approach. If the husband breaches a valid stipulation he agreed to, the wife has a significant remedy. She can go to court and seek a dissolution of the marriage.
A dissolution. She can end the marriage because he broke that specific promise.
Yes. The logic is straightforward contract law, essentially. He broke a valid term of the contract he freely entered into. Because he's in breach, she's no longer bound either, and she has the right to ask the court to dissolve the marriage based on his failure to uphold his end of the bargain.
It's completely different from the majority view, where the breach of that void term meant nothing legally for the marriage itself. The Hanbali position gives these stipulations real enforceability.
It really does. The principle of pacta sunt servanda agreements must be kept has direct, powerful consequences here. It means couples following the Hanbali school can genuinely customize their agreement with enforceable protections.
It shapes the legal rights and remedies based on the actual terms agreed upon. It elevates those specific stipulations.
Profoundly so.
And this isn't just dusty old law books, is it? The source says this Hanbali idea, allowing more flexibility in stipulations, especially beneficial ones, has actually influenced modern legal reforms.
That's right. The idea resonates today. Allowing couples to tailor their marriage contract to fit their specific circumstances and expectations has appealed to reformers in various Muslim contexts.
The source mentions courts in the Indian subcontinent specifically. How did they handle these varying stipulations?
Well, courts there also ended up upholding the validity of many such stipulations, but interestingly, their reasoning wasn't always a direct import of Hanbali jurisprudence.
So, similar result, valid stipulations, but maybe a different path to get there.
Often, yes. Their approach frequently involved viewing Muslim marriage, despite its religious dimension, as fundamentally a civil contract in the eyes of the law.
Framing it as a civil contract, what does that unlock legally?
If you view it primarily as a civil contract, then its terms, including stipulations, can be assessed using the principles of secular contract law. In the context of the Indian subcontinent, that often meant applying the Indian Contract Act of 1872.
So regular contract law applied.
Essentially, yes. A stipulation in the marriage contract would be valid as long as it didn't violate the general principles of contract law, just like any other private agreement. The source gives us a really potent quote on this.
Oh, yeah.
It's from a case called Muhammad Amin v. Amina Bibi. That's AIR 1931 Lahore 1934. And in that case, Justice Addison stated very clearly, marriage is a civil contract, and the parties can contract in any way they care within certain limits.
Marriage is a civil contract, and the parties can contract in any way they care within certain limits.
Wow, that quote from Muhammad Amin v. Amina Bibi really nails it. It shows how that civil contract perspective allowed courts to validate terms that might have been struck down under the traditional majority Islamic view. It's a fascinating example of how legal systems adapt. They might emphasize certain principles within the religious tradition itself, like the Hanbalis did with Surah 5.1, or they might classify the institution in a way that brings secular legal norms into play, like those courts did.
Okay, let's quickly recap this crucial section. Stipulations reinforcing normal stuff, universally valid. Stipulations varying normal stuff. Under the majority view, Hanafi, Maliki, Shafi'i, Moshia, they're void, but the marriage is saved by the doctrine of severance, based on the idea of immutable effects.
Right.
But UT, under the Hanbali view, relying on Surah 5.1 and Pacta Sunt Servanda, these varying stipulations are generally valid. And if breached by the husband, the wife can seek dissolution.
A critical difference in remedy.
And modern courts, like in India, sometimes reach similar conclusions by treating marriage as a civil contract, applying secular law, as seen in Muhammad Amin v. Amina Bibi.
That sums up the landscape for varying stipulations, conditions that, at worst, are themselves voided, but don't take down the marriage itself in these views.
Okay, that brings us to category 3, the big one. Stipulations so bad they invalidate the entire marriage contract.
Yes, these are conditions seen as fundamentally incompatible with the very essence of marriage. According to a particular school's understanding, they strike at the root definition.
And what is that essence for most schools?
For the majority, that's the 4 Sunni schools. Hanafi, Maliki, Shafi'i, and Hanbali here, plus the Ismaili sect of the Shia. The core essence of marriage is its permanence. It's understood as a lifelong union, intended to last until death parts the couple.
Permanent, lifelong. Got it. So if a stipulation directly clashes with that idea,
Then it's seen as fatally flawed. It undermines the whole basis of the contract. And the classic example the source gives for this category is putting a time limit on the marriage.
stipulating a duration, like we agree to be married for 5 years.
Exactly that. For the vast majority, those 4 Sunni schools and the Ismailis, any clause in the marriage contract setting a fixed end date is fundamentally contrary to their definition of marriage as permanent.
And the consequence of including a time limit like that.
It's drastic. The time limit stipulation invalidates the entire marriage contract. The marriage is considered void ab initio from the very beginning. It's not about severing the clause. The whole agreement fails because it tried to create something that, in their view, isn't a valid marriage.
So for most schools, a marriage contract with a built-in expiry date is just not a marriage at all.
That's their stance, based on that core principle of permanence. But just like the Hanbalis were the exception on varying stipulations, there's a major exception among the Shia when it comes to time limit.
Ah, yes. The Ithna Ashari Shia. This is another absolutely crucial distinction to grasp.
It really is. The Ithna Ashari sect holds a different view. They do consider stipulations imposing a time limit on marriage to be valid.
They see time limits as valid. That seems to completely contradict the permanence idea.
It does from the majority perspective. But for the Ithna Asharis, this acceptance of a valid time limit gives rise to a distinct legal institution. Muta, often translated as temporary marriage.
Muta, temporary marriage. So for Ithna Asharis, adding a time limit doesn't kill the marriage. It actually creates a specific, recognized type of marriage contract, the muta.
Precisely. It's a valid form of marriage within their legal system, specifically designed around the idea of a fixed term. It's distinct from their concept of permanent marriage, which they also have called nikah.
This is a radically different approach. We really need to explore muta in detail based on what the source tells us about its rules.
Absolutely. Let's unpack it.
Yeah.
So, muta is a form of temporary marriage, legally valid only within the Ithna Ashari Shia tradition. Remember, the Sunni schools and Ismaili Shia would deem any marriage with a time limit completely invalid.
Got it. Only Ithna Ashari. How is a muta actually formed? Is it a formal process like nikah?
Yes, the source indicates it's similar in formation. It requires a clear offer and acceptance between the man and woman. So it's still a formal, consensual contract, not just some informal thing.
Offer and acceptance. But the content and rules are very different from a permanent nikah, right?
Oh, profoundly different, reflecting its temporary nature. Let's run through the key features the source lays out. First, money. The wife receives a payment when the contract is made. Similar idea to dower, but here's the difference. In muta, this payment is not called dower. More, it's specifically referred to as salary or wages.
Salary or wages. Interesting term. Why the distinction?
Well, using salary or wages might emphasize the temporary nature payment for a defined period of association, rather than the lifelong commitment symbolized by mar in nikah. It frames it more as a direct exchange for the duration of the contract.
And the time limit itself.
It's essential. The contract must specify a time limit, and this limit can be absolutely any duration the parties agree on. Could be an hour, a day, a month, years. Total flexibility on the agreed term.
Any duration. Wow. Okay, what about the usual husband-wife duties we see in nikah? Like the wife's obedience, the husband's duty to provide maintenance.
This is a huge difference, spelled out clearly in the source. In muta, the wife has no obligation to obey her husband, and correspondingly, the husband has no obligation to maintain her.
No duty of obedience, no duty of maintenance. That really changes the dynamic compared to nikah, doesn't it? It sounds much more like a specific agreement for companionship for a set time without those broader household duties.
It defines the relationship very differently, yes. focusing on the consensual cohabitation for the term rather than the wider mutual obligations of a permanent nikah.
What if children are born from a mute marriage? What's their legal status?
Very important point. The source is clear. Children born from a mute union are considered legitimate.
Legitimate. Okay, so despite the temporary nature and different rules, the children's rights and lineage are protected, same as in a permanent marriage.
Yes, the law ensures their legitimacy and associated rights.
How about inheritance? In nikah, spouses inherit from each other. Does that happen in mita if one partner dies during the contract period?
No. Another key distinction. The source states explicitly, if either the husband or wife dies while the muta contract is still active, the surviving partner does not inherit from the deceased.
No inheritance rights between muta spouses. That really underscores the temporary, limited nature of the legal bond compared to a permanent marriage.
It's a direct consequence of it being time-bound.
Can muta be ended before the agreed time runs out?
Yes. The source says either party can terminate the marriage at will even before the specified duration expires.
Either party can just walk away early. What are the financial implications if they do?
There are specific rules. If the husband terminates early, he cannot get back any of the money, salary, or wages he's already paid her.
He forfeits what he paid. What if the wife terminates early?
If the wife ends it before the term is up, she must repay the husband a proportionate amount of the money he paid her. The repayment is calculated based on how much of the agreed time she didn't complete.
So she gives back the wages for the time she didn't fulfill. Seems like it keeps the financial side tied directly to the time spent together.
It aligns with that salary for duration concept, yes.
When the muta ends, either on time or early, does the woman have to observe a waiting period? An Ida?
Yes, she does. And Ida is required after muta ends. The duration given is 40 days. Unless she's pregnant, in which case the Ida lasts until she gives birth.
Ida of 40 days, or until birth. Same basic purpose as in nikah, check for pregnancy, clarify lineage, but a specific, often shorter duration.
It's a standard post-termination requirement.
What about polygyny? A Sunni man in nikah can have up to 4 wives. Is there a limit on muta wives?
Another very striking difference here. According to the source, a man can have an unlimited number of wives through muta contracts simultaneously.
Unlimited muta wives. That is drastically different from permanent marriage rules. It really highlights that muta operates under a separate set of legal and maybe social assumptions.
It certainly points to a different function or understanding within Ithna Ashari law.
And finally, how does the muta end automatically when the time limit is up?
It dissolves ipso facto. That means just by the fact itself, the fact that the agreed time has expired, no need for divorce, no need for any action, the contract simply ceases to exist legally when the clock runs out.
Automatic termination. Truly temporary by design. But what if, practically speaking, the time runs out, but the couple just carries on living together? Does the law recognize that?
Yes, the source anticipates that. If they continue cohabiting after the official expiry date, the legal assumption is that the term was implicitly extended for the entire period they kept living together.
So the law presumes they silently agreed to keep the temporary marriage going.
That seems to be the inference drawn to cover their continued relationship. And crucially, any children conceived during this extended period of cohabitation are also considered legitimate.
That's pragmatic. It protects the children born during that continued time, even without a formal renewal.
It prioritizes lineage and legitimacy.
Okay, let's quickly recap the key features of muta under Ithna Ashari law. Because it's unique. It's a recognized temporary marriage. Needs offer acceptance. Wife gets salary or wages, not dower. Must have a time limit, any duration. Wife has no duty to obey. Husband has no duty to maintain. Children are legitimate. No inheritance between spouses. Either can terminate early, husband forfeits payment, wife repays pro rata, woman observes Ida, 40 days or until birth. Man can have unlimited muta wives. Marriage ends automatically, ipso facto, at expiry. But continued cohabitation implies an extension, and kids conceived then are also legitimate.
That's a solid summary of the muta framework as laid out in the source. Really highlights how distinct it is from nikah.
Right, so we've covered a huge amount. The easy valid stipulations, the big split on varying stipulations, majority versus Hanbali, the civil contract angle in modern courts, the conditions that kill the whole marriage, time limits for most, and then this major Ithna Ashari exception validating time limits through the whole system of muta.
We've worked through those 3 categories: valid, void but marriage okay, and contract invalidating, seeing the different legal takes on each.
And we saw the principles driving them. The majority's focus on immutability versus the Hanbali's focus on freedom of contract and Pakistan Servanda from Surah 5.1. And that fundamental difference in defining marriage's essence permanence versus allowing temporality via muta. We hit key terms like the doctrine of severance, the case of Muhammad Amin v. Amin Abidi with that quote, marriage is a civil contract, and all the specific rules of muta. Repeating these is vital if you're studying this.
Absolutely. And understanding why these differences exist is more than just academic.
So why should you, the listener, care about all this, especially if you're facing an exam?
Well, for starters, it shows the incredible richness and diversity within Islamic legal thought. It's not just one single answer. Learned scholars develop different reasoned positions based on their interpretations.
It also shows how legal reasoning works. Watching the Hanbalis pull Pakistan Servanda from Surah 5.1 to justify valid stipulations, that's legal methodology in action.
And practically speaking, these distinctions matter hugely. Whether a condition you agree to is valid, whether your marriage itself is valid, can literally depend on which legal school's view applies. It affects real rights, real obligations, real choices.
Understanding this helps you make sense of why you might see different rules or practices in different places or communities. It gives you the why behind the differences, making it less confusing.
And for exam prep, the source itself guides you. What are the limits on stipulations? How do schools differ? Why? These are the core questions.
Yeah, and the source even gives that perfect sample exam question that ties it all together. To what extent can the contracting parties to a marriage change the incidence of the traditional Islamic law contract?
To what extent can the contracting parties change the incidence? A great question. Answering it well means laying out these different perspectives we've discussed.
Exactly. You'd start with the traditional majority view non-Hanbali, where only reinforcing conditions are okay, and varying ones are voided by severance, leaving the marriage valid, because of immutable effects.
Then you absolutely have to contrast that with the Hanbali view. Explain their validation of varying stipulations based on Surah 5.1 and Pacta Sunt Servanda, and the crucial remedy of dissolution for breach. Maybe mention the civil contract influence, like in Muhammad Amin v. Amina Bibi.
And then pivot to the third category stipulations that invalidate the whole contract. Focus on time limits being the key example for the majority, because permanence is the essence. And then explain the massive exception. The Ithna Ashari recognition of time limits through muta, outlining its unique rules, salary wages, no obedience maintenance, no inheritance, 40-day Ida, unlimited wives, ipso facto expiry, extension by cohabitation.
Nailing those points, explaining the reasoning, using the key terms, severance, Pacta Sunt Servanda, Surah 5.1, Muhammad Amin v. Amina Bibi, Muta, that shows a real grasp of the material.
So there we have it, a deep dive into the really complex legal world of stipulations in Islamic marriage contracts. We've seen the agreements, the disagreements, the different ways of defining the marriage bond itself.
It's an area that shows how interpreting foundational texts can lead to really diverse legal paths, affecting everything from money to the end of the marriage itself.
Thanks so much for joining us for this detailed look. And remember, this discussion drew heavily on educational materials, thankfully made available by the University of London. This deep dive was brought to you by Sinorbit Academy, Sri Lanka.
And yes, again, to everyone studying this, especially if exams are looming, really, the best of luck. Getting these distinctions clear is crucial.
And just as a final thought to leave you with, if these respected legal schools can look at the same core texts and principles about something as central as marriage and arrive at such different conclusions, void versus valid, permanent versus temporary, what does that tell us about interpreting legal or religious texts in any tradition? How do societies or even individuals navigate these kinds of deeply held yet divergent viewpoints?
Something to definitely think about as you continue learning.
Until our next deep dive, keep thinking, keep questioning, keep digging for those insights.